Hi, everybody. This is Paul Hitchcock. I am with the asset protection, estate planning, and business planning firm Barth Calderon. And this is our channel, Wealth Protector TV, where we have credible people doing amazing things on here and great content that we love to give out to help you get organized with your planning. And today we are, as you can see there, talking about probate and trust administration. I want to introduce first Christopher Anderson, who's the co-founder of New Leaf Family out of Colorado. And then Phil Shakurlian, who is a partner with Barth Calderon, one of our top attorneys, oversees the probate and trust administration department. Christopher, I want to start with you. Just a quick few minutes on what you're doing and your focus with your practice.
Well, sure. Thank you. And Paul, it's great to be here. Phil, thanks so much for hosting this. New Leaf Family and New Leaf Legacy are law firms in here in Colorado that serve our clients in helping them to protect their families. I mean, that's what we are all about. So, New Leaf Family represents people that are going through changes in their family, divorce, custody, things like that. And New Leaf Legacy, and that's mostly what we're going to be talking about here today, is a firm that protects and helps family protect their future. And in a sense, that's what ties our firms together. Is our firms are all about families' futures. And we're all about protecting them through transition, but also in the long haul to make sure that they're doing the right things to make sure that their assets and that their legacy, that's why we named it that, is protected.
Love it. Thank you, Christopher. Yeah, Alliance is great, and I know that your clients see you as a trusted advisor and for all things going on in their life. So the Alliance really works well. Phil, let's get into this. Want to get into the slides here. Should we just kick in?
Let's do it.
Okay, move along here. All right. Why this matters. Phil, let's run through this and hit some of these. And Christopher, you want to jump in at any time, perfectly
I
fine.
might
Would
not
love
be
it.
able to help myself, but we'll see.
Oh yeah, you're not a man of few words. We love it. All right, Phil, let's
No,
go.
no attorneys ever are.
No,
Um,
no.
all right. So yeah, having the right plan in place is super important to avoid a lot of these circumstances. And when I say having the right plan in place, that means having a trust and having the trust written properly. Not all trusts are created equal. Not all attorneys are created equal. And just because you have a trust doesn't mean you're going to avoid these situations. And not having the proper planning can cause delays to your heirs. It can make it extremely difficult to get to bank accounts, retirement accounts, any type of financial assets you may have. A lot of times it leads to family disputes, and family disputes are like the worst thing you could possibly have. Now you've got litigation going on. It takes time to distribute the estate. It costs a lot of money. Most of the time, the lawyers get the entire inheritance rather than the beneficiaries. And even worse, if the siblings are talking about now, siblings that were getting along prior to the death of parents they now hate each other and they'll never talk again. And who wants that for their kids? Um, Trustee confusion, man. If you put more than one trustee or it's not clear what trustee has what powers, that is another thing that leads to litigation. It's one of the top disputes that we see.
And I was going to ask Christopher to chime in here real quick on this. Is Christopher, on our end, we see so many families that don't have any planning in place, and they come to us, and there's problems going on. On your end, when you're talking to folks, do you also see outdated planning? Do you get into this sort of focus a bit?
Outdated or non-existent, or
Yeah,
really, Phil, the worst to me, and it kind of goes to um, what you were saying is that it's the people, and I'm sure you see this too, who think they've got it covered, right?
yeah.
They got some document offline or whatever, and they think they got it covered, and then they learn that they didn't. And so, it's one of the reasons that we partner with Barth Calderon is to make sure that the clients that we're working with at New Leaf Legacy have documents that work, that documents that actually protect them. And because it's a very sad thing when it's too late, right? When someone's already passed, to try to fix this. And Phil, I think you were laying out, um, some of the real downsides to what happens when they don't have this figured out.
Well
Absolutely.
said. Yeah, and a big deal for us as we get into the second slide here is making sure people understand the difference between probate versus trust administration.
Hmm.
Phil, you want to jump in here?
Sure. Yeah. Again, the probate is the court supervised process. Everybody can look up your assets and who your beneficiaries are and family information. Whereas if you have a trust and you're going through trust admin, it's all private. There's no public information there. Um, the probate can take anywhere from a year to 2 years, whereas a trust admin can be done in anywhere from 3 to 6 months. There's a lot more flexibility with a trust admin and swapping assets between beneficiaries or beneficiaries buying each other out, where in probate you don't have that option. Um, and and if you have a trust and you have assets in the trust, but you may have some assets outside the trust, you may have to do both. The assets outside the trust may have to go through probate, and the ones in the trust may have to go through trust admin. And now you've got two completely separate tasks that you're having to do and deal with.
Yeah, we this came up the other day, Phil, in a talk where we see families where they have assets in different states, like rental properties, right? They'll own a portfolio of rental properties. Properties end up going through probate in two different states, which means, correct me if I'm wrong, or comment on this, is going through probate in two different states.
Absolutely.
Yeah, multiple processes, multiple fees, multiple legal fees. It gets very expensive. And the sad part is, like with modest estates, we often will see it all go into legal fees, like or
Yeah,
almost all
Hmm.
of it. Like nothing, it's not what anybody wanted, and that's what ends up happening.
yeah.
Yeah. When families fight, the attorneys win.
Yeah, I've never seen a will yet where it says, and I wish for all of my worldly goods to go to my lawyers. Like nobody
Yeah.
actually
Absolutely.
writes that. Nobody
I
intends that.
try every time when I talk to the clients to get them to leave it to me, but it just doesn't work.
Yeah.
Yeah, yeah. No conflict there at all.
Yeah.
Uh, all right. So people say this. We have a trust, so we're fine, right? And Phil, any additional comments on the trust planning side of it here?
Yeah, again, the assets have to be properly funded in the trust. So real estate, you need to title deeds and file that with the county recorder. But beware, you want to make sure that you're not triggering any property tax or transfer tax issues. Investment accounts, you want to change the title and beneficiary to the trust. Any retirement accounts, you want the beneficiary, potentially primary, sometimes contingent beneficiary to be the trust. And you want to make sure all those designations are taken care of. Just having a beneficiary designation of your kid or your spouse isn't going to cut it if something were to happen to both of you unexpectedly.
Yeah.
Christopher, I was going to ask you that. I imagine with the family law clients, I mean, isn't it a reality that someone goes through a divorce, that they've got to redo their planning, right? And they need to, especially if they're getting remarried, that can
Oh
complicate
gosh.
things.
Yeah, and sometimes we see people with a trust that's actually gone through marriage, divorce, marriage again, and divorce again, right?
Yeah,
And yeah, most of it's can be invalidated by that. There's some things that can survive, but a lot of it is invalidated. And so it's as if you don't have one. And But basically, like I think the message to convey here is that when you've gone through a family change, particularly a divorce, you don't know, right? You're like, you don't, what I promise you is you don't have what you think you have. And you don't know what's changed and what's invalidated and what's not. And that's a good time. You know what? You should be re-upping, redoing, rethinking your estate plan periodically anyway. But that's certainly one good time to do it because it also probably means your priorities and values have changed.
yeah, for sure.
And so regardless of whether the law invalidates it, probably it's not valid to what your new life is. And so it's a good time.
Yeah, and I was going to ask Phil, do certain assets pass by, by contract, 401ks, insurance contracts? As a beneficiary, do you put someone's name directly on there? Like, so it's going to your a kid, or do you put the trust as the beneficiary?
That's a individual decision for each different client. And usually the answer is the trust, but for some clients, it might make more sense to put a kid. And so that's something that you need to talk about with your attorney to see which is going to be best for you.
Yeah, and
Y-
then of course, Paul, like when
Yeah,
you're doing that, making sure that plays with what your other decisions are in the trust, right? So if you're saying, okay, this asset's going to go directly to kiddo one, well, now kiddo one's partially taken care of, and we need to make sure that that plays with what else we're trying to do inside the trust.
yeah, yeah. Well said. Okay, I'm going to blaze along here. Great stuff. All right, trustee responsibilities, and this one always hits me because over the years I've been asked to be a trustee, and when I looked into it, my answer was no, thank you. I didn't want it. I mean, it's just people don't
It's a
realize
big
what's going on.
responsibility.
Yeah, big. So let's both of you comment on what this is all about.
So yeah, it's like we were just saying, it is huge, right? It's a big, big responsibility that has, where you as a trustee, like to put it in the most simple terms, you are being trusted
Yeah,
by the person who created the trust to act as they wanted, right? To stand in their shoes and execute that trust in the way that they define it, that they trusted you. We're using the word trust a lot, but that's where we are, right?
yeah,
That they trusted you to act so that their will, their desires, their legacy, again, is preserved through that trust. And you could, as a trustee, depending on who the beneficiaries are, you can take a lot of heat. Some people
yeah.
want you to do things that are not in keeping with what the wishes of the devisee were, and will try to get the trustee to do things that the devisee might not have wanted. But so the main responsibility of the trustee is to follow the terms of the trust, not to substitute your thinking, not to substitute your sense of what's right, but to execute it according to the terms that the person who created the trust wanted.
Well, I see pay taxes and expenses on there. The
Yeah.
trustee is not expected to be an expert in taxes. They can bring somebody in, correct?
It can and oftentimes should if there's ever a
Sure.
conflict. Like yeah, the if it's a substantial trust that's going to owe taxes, there should be the trust has to do a tax return just like a
Yeah.
person. So and then the tax return should be done by a professional. If the t trust is going to devise real property, let's say if it's going to actually deed property to someone, you should use somebody who's a professional in that. The trustee, their job is to make sure things happen the way that the person who created the trust wanted them to happen, and to use
Hmm.
all the same professionals that that person would have used in order to make sure that happens the right way and in a way that honors their legacy.
And I know what you're going to say about this because we've talked about this before on the communication side. Open communication amongst people, trustees, kids is paramount to this thing working well. Is that a fair statement?
It's a fair statement. It's a difficult one, right? Because,
Yeah.
um, you know, again, it's always great when everybody's communicating. It's when they're not or when they won't, and that the trustee's job can be made more difficult.
Yeah.
And that's where, but I think it's the trustee's job to make sure they're communicating. And if everybody else doesn't want to, well, that's that can be their choice. And because the trustee is held to a standard and can actually be held liable for making mistakes, for not doing things according to the way that the devisor of the trust wanted.
Yep. Great stuff.
Yeah.
All right, you're comfortable handling common mistakes. I'm going to have you address some of
Uh,
these here. You see these here. Comments on these, things that you would say that are a big deal. Maybe all of them.
Yeah, so now we're going back to really talking about the creator of the trust, right? The people who are
Yeah.
listening, because your beneficiaries may or may not be listening, but you're thinking about creating a trust, and the common mistakes that we see with clients all the time, is they come to Barth, they come to us, and we work with Barth to create their documents, and then they don't read them,
Yep. Yep.
and like they presume that somehow, despite we try really hard to make sure we understand everything that they wanted to have happen, but like that we don't have telepathy, and we may have misheard something or misinterpreted something. And so it's really important to read that trust. It's
Yeah.
also important then to keep really, really good records. That's another mistake is people then, just don't keep records. So that when they do pass, what goes into the trust is not clear.
Hmm.
Um, and the other key mistake, and this one's huge, is once you put things in a trust, they're in the trust, right? People like kind of treat it like that's still part of their own bank account, their own assets, and they really have to treat it like you put them over here in this box. It's not
Yeah.
your box anymore. You're as you know when so a lot of times the person who created the trust is going to be the trustee while they're living, but as the trustee, they have those same responsibilities that I talked about before. And so that's another huge mistake is like really playing loose, fast and loose, because that can damage the separate entity of the trust and then cause other people to try to say that trust is not valid or those things should not pass through the trust. Those
Yeah.
are really the biggest mistakes.
Yeah, because Phil, you see people that can make a mistake of like upon, doing distributions for the trust, they'll be moving money from trust accounts into their personal accounts to make distributions. Huge red flag.
Absolutely. Yeah. You got to have one coordinated plan and follow it and not start doing things on your own.
Okay, no, great, good, very good reminders here. Family disputes. Okay, we talked a little bit about this, and I want to ask, and this is how do each of you, and Christopher, maybe you can chime in here first, and Phil, you also, is how do you initiate discussions with the family as you're going into this? I mean, do you sit everybody down? I imagine not all families are close. There's got to be an art and a science to doing that. What is it?
Yeah, I mean, so there's this notion, right, of the reading of the will. Movies love it, right? There's
Oh
now
yeah,
going to be the reading of the will, and everybody's like going there and like, damn, I didn't get the card.
Agatha Christie, Agatha
Yeah,
Christie.
yeah.
Yeah, so yeah, I love that.
And my experience of this is it's in these days it's digital communication. There's no, we let people know, that the beneficiaries, what they are, what they can expect, et cetera, going forward. Um, I think the highlight is the one that I'd want to talk about most, and I'd like Phil to really, take the lead on this, but is the perceived unfairness, because that's where we get in, right? And the truth is that there are almost always going to be beneficiaries who think it's unfair. If everybody thought it was fair, we probably wouldn't have needed the document in the first place. I mean,
Yeah.
it still avoids probate, it avoids a lot of other problems, but it's the desire of the person who created the trust, and it doesn't have to be fair. And that's one of the things that I explain to folks is like, listen, I'm not here to be fair. I'm here to do this the way that the person who created the trust wanted. And you may think it's fair, you may think it's unfair to you, like you're getting more. You can always go give some stuff away. That's fine.
Yeah,
And you
yeah.
may think it's unfair and that you're getting too little. Well, that's a conversation among you and your family. I'm going to, or the trustee is going to distribute this according to the terms.
Phil,
And
what do
fair
you say?
and
Yeah,
yeah, fairness, you could have a family with two kids and it's split 50-50 between the two kids, and one of them still thinks it's unfair.
Hmm.
One of them thinks I spent more time taking care of mom and dad while you moved away to another state. And so, perceived unfairness doesn't have anything to do with percentage. It's what somebody sees in their head. And so we sit down with the clients and we try to get them to talk these things out. First we'll sit with the clients and try to draw out what they really want. That's something that a lot of times they haven't even thought of on their own. And so we have that conversation with the client. And then we tell them, okay, do you want to discuss this with your kids, your trustees, your agents, and see what they think? See if they're willing to accept appointments. See what they would argue if you were to die and this would happen, and try to get them to talk it out as much as possible. The more communication they have, the less chance you're going to have of fighting when you die.
yeah. And we see this really come to the surface a lot when there's a family business and one kid works in the family business, one doesn't, and the one kid is like put in all this time to build a family business, and then it gets screwed up because they go, all right, well, how do you divide assets if there's rental property, family business? Maybe you don't give split the business 50-50 with a kid who's never worked in it. I mean, Phil, you see that all the time, right?
Absolutely, yeah, and it's it's a tough situation. You can say that the kid that works in it gets all of it, and then offset it with another asset from the estate for the other kid that doesn't work in the business. You could maybe give both kids an interest in the business, but only the kid that works in the business a controlling interest. There's many different ways to handle that. You could have a life insurance payout to buy one kid out of the business. It's something you got to talk about with the clients and see what they want on each individual situation.
Yep. Well, yeah, at all costs, avoid family disputes is the bottom line. Rental properties, want to hit this quick here. We have many clients that own rental, portfolios of rental properties. We're speaking to apartment associations, and this is a big deal. How do you deal with rental properties? Phil, comments?
Yeah, so it's important to put your all of your real estate in the trust because if you don't, they're going to probate. There's not really many tricks in any state to avoid probate for real estate. So first and foremost, make sure it's in the trust. But you may want to actually put it in an LLC and then in the trust, so you get some asset protection and tax benefits. You don't want to just throw every property in an LLC. It's on a case by case basis to see what's going to be the best for you.
Yeah, Christopher, what do you say about the property piece of this?
I think the key here is making sure it's like so what we've transitioned like we've been talking so far about really what happens. Okay, the trustees putting property in the, I mean, sorry, the creators putting property in the trust for their beneficiaries. What we're
Hmm.
talking about here is actually very, like, I think somewhat more interesting, is it's actually managing property during your lifetime. You create a trust and you can operate these things and hold these things inside the trust, and if you do it um with great intentionality and you create the trust properly, this can create benefits for the owner and for their beneficiaries today. And then, the transfer at time of death, it becomes much more controlled, much more planned, as long as, again, that trust has that plan in it. So this is a great way where trusts really start to improve the management of property both during life and afterwards.
Yeah, and Phil, you in California, we've got Prop 19, and this
Absolutely.
comes up for you. I mean, it can get complicated depending on what state you're in. Prop 19 can be a hornet's nest, right?
Yeah, and California, you've always got to worry about triggering a reassessment. Florida, Hawaii, you got to worry about triggering a transfer tax.
Yeah.
And so you really have to be careful and do not try to navigate this on your own.
No, no, Colorado's got the same thing. And like you can manage that, right? But if you're not careful, you will trigger that tax. And quite a tax is, at this point, is just a removal of value from the estate.
Yeah, yeah.
When nothing actually happened. And so that's a terrible result.
Yeah. Yeah. And I always see that there's so many disparate planning areas involved in this scenario. I mean, there's taxes, there's asset protection, there's estate planning, there's, financial planning. And if those are not coordinated at some level, it's bubblegum and toothpicks is what we see often.
Yeah.
All right, as we get here to the wall, I want to hit this last one here, closely held business challenges. Phil, what say you?
Yeah, we kind of hit on this. It's who gets to inherit the business, but at death, it's who gets to inherit the business and in what sense, and how to make it fair for the family. But while you're alive, you need to plan for other possibilities, your incapacity, your retirement. What's going to happen in those situations if you have partners? What's going to happen when you die? Does your wife and kids now step in and become partners with your partner? I don't think your partner would appreciate that. So you really need to make sure you have a proper business succession plan. Make sure you have a buy-sell agreement, maybe some kind of funding to buy the deceased partner's family out using life insurance. There's many, many things to explore here. This is a whole nother complicated level of planning.
Yeah, and there are some businesses that you can't inherit. Law, right?
Right.
You're a lawyer and your family's not. And all of a sudden, now they may be partners with your business partners, but they can't be I think like, oh my goodness, the challenges that can pose. This all needs to like really can be benefit from good planning.
Can it actually happen where the business can function can be frozen because it got nailed by probate or something's going on where it actually will impact the ability for the business to run during this process?
Yeah, happens all the time, right?
Yeah.
And sometimes the court will appoint a receiver. Somebody who quite honestly doesn't have the passion. It's just a bureaucrat basically who's going to operate the business. With a fiduciary duty, but and meanwhile everybody else is locked out. It can be disastrous. So the good planning here is so important
To
to avoid losing value.
even get to that point where you have a court appointing a receiver, it can take months, and the business can fall into, it can fail in that time. How do you
Yeah,
pay your employees? How do you pay your vendors? How do you, deal with contracts? How do you get supplies? Things like that. It can all just fail in the time when you're waiting for that to happen.
yeah, exactly right.
Been great. We're hitting a wall here on timing. This is a great quick hit. We love doing this education just to get people thinking about things, thinking about their own planning.
Yeah,
Christopher, Phil, really appreciate you both being here. Any last words?
a little bit of planning is it really it gives peace of mind,
Yeah.
but it also like can actually enhance the value of what you've built during your lifetime to yourself and to your legacy. So I just think this stuff's so key. So thanks so much for hosting this, Phil. Paul, thanks for the great questions. And this is why we work with Barth Calderon, because having this team look out for our clients alongside us is just a great advantage.
Love it. Thank you for those nice words. Phil, thank you.
Thank you.
Yeah, we'll see everybody again soon.
All right, y'all take care.
Okay.